Good morning, everyone. Welcome. Good. Oh, you're all excited today. Welcome to law school. I'm glad to be with you today. This is your second day of orientation, right? How's it going so far?
Great.
Busy, overwhelming, a lot of work? Okay. Orientation is very important. I remember back when I was a 1L, when I first started law school, and I walked into the room and thinking, what the heck is this, right? What is a case? What is a brief, right? What does it mean to brief a case? What does it mean, all these funny terms that I don't understand, like giving an opinion that's 6 pages long? Oh, no problem, read it 20 minutes, right? How long did it take you to read this? A lot longer than 20 minutes, right? The reason why we have this orientation is to get you acclimated for what's going to start on Monday. And actually it's already started because you have your assignments already. Law school doesn't have much of a learning curve, unfortunately. On day 1 of class, you are expected to hit the ground running. Reason why is we believe in you. We accept you to this law school. It's a selective school. We chose you. We looked at your credentials. We looked at your qualifications. We think you can do this. So we've given our confidence in you. And starting on Monday, you need to throw it back at us. Okay? So what I want to do in this class is not to teach you property law. You will learn this. You may have me in the spring for property 2 or for property 1. What I'm more interested is in getting you in the right frame of mind to understand what it is going to be coming of you on Monday, okay? The reason why is that law school can be very shocking and jarring because it's probably unlike anything you've ever studied before. The way professors teach and expect of you is probably far different from what you had in college or maybe even other graduate degrees. Law school is very unique, okay? So I want this to be open. I don't know any of your names. I don't even look at the roster, so I won't remember if you say anything. Whatever questions you have, feel free to ask. My name is Josh Blackman. If you want, you can email me later. I promise I don't have any of you this fall because I don't teach any of your classes. So if you want to have a question and you're embarrassed, you can look me up on the faculty register and I'd be happy to answer it. Because I remember back to my first day of law school, and if I give you this little anecdote, you'll be more at ease. So you all have contracts, right?
Yes.
And if you all bought the book, Restatement of Contracts, okay, if you haven't, you should. Okay, so, and you've also bought a textbook for contracts, right? Okay, so this genius, right? So for the first day of school, I go to class and there's a syllabus for contracts. And there's 2 books. There's the textbook and there's the restatement, okay? The professor didn't specify which book we had to read from. So we could have either read pages 1 through 20 from the textbook or pages 1 through 20 of this big code called the Restatement of Contracts. I read the wrong one, okay? I read from the wrong book on the first day of my first law school class ever. It was humiliating because I walked into the room looking, I was like, wait a minute. No one has the restatement book even open. Everyone has the other book open. I'm like, I didn't read that book. I'm thinking, okay, I'm in trouble. And I remember I frantically sent the professor an email saying, you know, I didn't do the reading. He never bothered to reply. Fine. But we go to class and he starts calling people. Like, oh my God, I'm dead. I didn't do the reading. What am I going to do? My entire law school career is finished before I even started. Okay, so we get to a point, and you'll have this, where the professor's asking a question, and the answer was not in the case that you read. I promise you this will happen. Very often, a question professor will ask you isn't in the case. This is what makes you lawyers, right? You have to see what's in the case and build upon that to answer some other question, which isn't at all obvious. So this genius, right? I had read the other stuff where the answer was. And I remember raising my hand and saying, Professor, I know the answer, right? And here's the answer, whatever. And he's like, how'd you know that? I'm like, okay, page whatever of this restatement. He's like, he flips in his book. He's like, Mr. Blackman, that's correct. I'm like, okay, I got this, right? I tell you this because, look, I'm standing here now, okay? You can learn, you can make mistakes, and you can still do great things. But you have to always work as hard as you can. Don't fall behind. I know it's tempting because you probably have 100 pages of reading for your first week of class already. Do it. Once you fall behind, it's virtually impossible to catch up. At least in your first semester. Maybe after you got a year under your belt, you can reevaluate that. I wouldn't recommend it. But always start off strong. Also, from a personal perspective, professors remember who's not prepared, right? Even if they don't write it down, they make a mental note. Oh, yeah, that kid's sitting right over there. He didn't know the answer. She obviously didn't do the reading. We remember that stuff, and that does count for a lot. Law school isn't just about getting grades, and this is something which is important to recognize. Your colleagues, your peers, your friends sitting to the left and right of you, these will be the bar, right? These will be the people who come with you through your entire career, who are opposing counsel, who are on the same team with you. If you ever need a favor, have a question, these are the people you're going to ask. Your professors will be your first recommenders in this world. Make sure they like you, right? If a professor likes you, when you graduate in 3 years, it makes your life a lot easier. If they don't like you, or if they don't know who you are, which is possible, you won't get much. Go to office hours. It's so disappointing when the entire semester goes by and I never see a student once. And then the student gets her exam score and says, I want to talk to you. It's like, okay, I don't know who you are, right? You're in a class of 90 people. You know, you're one dot. Maybe you had a good answer, I don't remember. But get to know your professors, right? And also take advantage of the experiences in law school. There's a lot of opportunity for networking, right? There are various happy hours. There are various, meetings with employers that have different information sessions. Go to them, right? Maybe you don't want to. Maybe you'd rather go watch TV or go to a party, whatever. You're in law school. Do things in the law school, and you'll meet someone. These are not dividends that pay off quickly. I trust me on this. When people are frustrated, like, man, I went to all these recruiting sessions, I didn't get a job. It doesn't work like that. Build your network, meet people, and learn people. And maybe 3 or 4 years down the road, you'll say, hey, weren't you at that happy hour at that firm reception? Oh, yeah. And then that's that. You can't do that after the fact. You only have one chance to make that connection. You can't do it 3 years later. Okay? And the final word of wisdom is to take care of yourselves. And this one I cannot stress enough. Law, the legal profession, has the highest rate of substance abuse, depression, and suicide. This isn't a joke, okay? You're about to go into a pressure cooker. And not just law school, the entire profession. More than anything else, you need to take care of yourself and your friends. If you see your friends are not doing well, or if yourself are not doing so well, there's help in this school. There's an office, you'll pass it. And if you need help, go ask for it. We can help you with these things. It happens every year that students burn out, that students get in bad places in their heads. Either they can't cope with the stress, or there's family pressure outside. Just take care of yourselves. No career is more important than your own health. It doesn't exist. And this doesn't just apply to law school. When you're seeking careers and vocations, say, oh, I want to be a top-notch litigator and I will work 90 hours a week and do all these great things. Well, those are great professions, but they come with costs to yourself and family. So pay very close attention in law school to how you react, how you work, your work ethic, but always keep an eye on yourself. Because if you don't, all the money in the world and all the law degrees won't mean a thing. Okay? Remember this. You'll forget whatever I tell you about foxes. You won't remember this in 5 minutes, but this I hope you do remember. Hopefully this leaves some mark on you, because this is a very stressful, tumultuous, often unrewarding experience. Professors don't always give good feedback. It's not our thing, but it's mostly for you and to take care of yourself and make sure that you are doing what you need to be doing for yourself. All right, any questions before we start talking about foxes? Any questions? Okay, and again, my name is Josh Blackman. It's in your syllabus. You can email me later if you have any questions. If you feel like answering public, that's fine. But this is an important time. The first few weeks of class is where you really set yourself. You make your friends. You form your study groups. Do it right the first few weeks, and then hopefully the semester will go well. All right, so let's talk about cases. All right, so you all come from a wide walk of lives. You had different careers, different educational backgrounds, but I'm pretty sure that none of you have had an educational style where you study only cases. What makes law school so difficult is that you're not studying from a textbook that someone wrote where they give you paragraph after paragraph talking about, here's the correct way to look at a physics problem, right? Or here's the right way to do a math question, right? No. What we have are cases. These are decisions written by judges. They may be current. They may be 200 years old. They may use a language that doesn't make sense to you. Okay? I promise this will happen. But what you're responsible for doing is reading these cases and saying, okay, Judge, what are you trying to tell me, right? What are the facts of this case, right? What's like the issue that the parties are trying to resolve? What does the plaintiff want? What does the defendant want? Okay. What is the ruling or the holding of the case? In other words, what is the rule? How do we take this case with these facts and apply it to a different case with slightly different facts? This is the process of learning by cases. We have a case with foxes like this. What if you have a different cases with ducks like that, right? How do we form the bridge? And there's no clear connection between the two. This is the thought process which you all have to develop. Okay? This is why we give you to start a case from the year 1805. And then why the heck are we reading a case from 1805? This is actually for your benefit. Why? Cases back then were a lot simpler. They were easier. You didn't have to worry with all these different statutes. There were no regulations, no administrative agencies, right? No environmental laws about hunting on a beach, right? We didn't have any of that stuff. You have two dudes hunting for foxes. And the sole issue in this case is who gets the fox. It's simple, it's easy. That's why I promise if you look at your readings for the first weeks of class, there are going to be a lot of British cases, right? There are a lot of cases from the early part of America, from the 1800s, whatever. That's why we're teaching you these cases. We're not trying to torture you. Also, they're generally shorter, right? This case is only 6 pages long, although it probably took you, if you actually read it closely, a significant amount of time. Okay, so this case, Pierce v. Post, is probably one of the most famous law school cases. I promise you, you'll take property in the spring, you will read this case. Every professor in the school, every professor from the country teaches this case. And the reason why is because there's so much good stuff in there, right? It's a fact pattern which anyone can understand, right? You have one guy, Post. He's a hunter running along the beach with his hounds trying to get a fox. And then you have this jerk, right? Pearson, who swoops in at the last minute and takes the fox away from Post. Okay, so the hunter Post sues. And then what's the court do? All right, so I want to start at a very foundational level and teach you a trick that I promise will come in handy. I'm sure you, can everyone see this on the board?
Yes.
I think I made as big as I can. All right, so let's start. Actually, let's start here. And I don't know your names. I'm just going to go up and down the rows and calling people. So what's your name? James. James? What's this star 175 business? You're going to be reading cases. You don't know what this stuff means. What's this star 175 business? Well, you see it says star 175 there. And then you got 177 there. And then you have 178 there. What do you think these numbers represent? Take a guess. How many times? By the way, when a professor's calling someone, other people don't call out. So James, what do you think? What do you think they are? 175, 77, 78, 79 later. What do you think these are?
Showing you the issues, maybe.
No. What's your name, sir? Hey, what do you think these are?
Referencing something.
Yeah, what do you think they're referencing?
Maybe referencing current law at that time.
No, a lot easier. Now what's your name? Kaylee, what do you think these pages are? I don't. What do you think the numbers represent? Yes, good guess, right? They're pages. Everything you read in law school was a judicial decision, right? And judicial decisions are organized in these books called reporters. I'm like, why is he telling me this now? Trust me, this will be useful. The way we have opinions is by these things called reporters. This is why, if I told you that Pierce v. Post is found at 3 Canes 175, you think, what the heck does that mean, right? 3 Canes 175. Well, it was a reporter. His name was Keynes, right? And he published opinions from courts. Yeah, before there was the internet, you had people publishing books. Remember this, right? So he had different volumes. There was Keynes #1, Keynes #2, and Keynes Volume 3. And in the third book of Keynes, right, on page 175, you will find Pearson v. Post. Look at this. The very first word, probably none of you even paid attention to, is significant. Why? Because in your legal writing classes, it's also called legal research. Remember the research part in writing? You're going to need to know how to find cases. So whenever you read an opinion, this little star 177 means, okay, that part of the opinion is on page 177 of this book, Keynes, Volume 3. We didn't even touch the opinion yet. You're learning so much, right? Okay. Let's go one more. Pearson v. Post. Let's go up here. So what's your name? Adam. Pearson v. Post, right? Pearson versus Post. Why is it not Post v. Pearson?
Doesn't have to do with their position in the case.
Good. Tell me more.
So the first one would be the one taking action against the other one.
Okay, so who is, what do we call the person taking action in a case, in a civil case?
That was the plaintiff.
Good. Like a plaintiff lawyer, slip and fall, right? The plaintiff is the person suing. And what about the second name, Adam? It's the defendant. The defendant is the person being sued. So a trick for you to use is the first name is usually the plaintiff, and the second name is the defendant. But, so Adam, I'm sorry, man, what's your name? What? Laurel. Do you know the different layers of courts? Have you learned about this before? Good, I'm glad they did. So do you remember roughly what they were? That's fine, Texas, any state. Any state works.
Well, it's moved it down at the bottom, municipal and like justice.
Okay. And then what if you don't agree with the municipal court? What do you do? Good. And then what do you do if you don't agree with the appeals court? Good, yes. There are different layers of courts, right? So what's your name? Isaac. Where is this case from?
This case is going back up to the original trial or preemption work.
This case, where is this case written from? You're one question ahead.
I don't know what state it's in.
Oh, it says it right there. No, I mean, I don't know. I don't care what state. What court is it in?
Oh, it's in the Supreme Court.
Yes. Okay. So this is what we call an appellate decision, right? This is not a decision from what's called the municipal court, or we might call a trial court, right? If I want to sue you, I'm not going to go to a court of appeals, right? If I want to sue you, I'm not going to a Supreme Court. I'm going to sue you in a trial court, the low-level court. That's where cases start. But this case is in the Supreme Court. It's at a higher court, a court of appeals, right? So, so what's your name?
Chase.
Chase. How do you get a court from a trial court to a court of appeals?
You petition
Who petitions?
the person who wants to fight the case.
The person who-
appellant, I guess.
Well, before you go to appellant,
Okay.
who is going to appeal in the trial court?
The person who lost.
Yes, exactly right. Why would the person who won file an appeal, right? That's stupid, right? You want to say, hey, I win, right? Right? No. The person who's doing the appealing is a person who lost. Okay. So, so what's your name in the back?
Jose.
Jose? So before reading this case, I know you read it, but pretend you never read the case, right? You know this case is in a court of appeals. Who lost in the lower court?
Pearson.
How do you know that?
They switched.
Yes. Whose name comes first, Jose?
The person taking the appeal.
Yes, exactly right. So this is a trick which I promise you will come in handy. The person whose name comes first is what we call the moving party, the person who filed the appeal. Or in the lawsuit in the district court, the person who filed the lawsuit. Whoever's moving, whoever's like taking the action, their name comes first. And whoever's opposing that action, post, comes second. So Jose, you said that Pearson's appealing. So did Pearson win or lose in the lower court? Everyone see that? Look at this. We got 15 minutes. I'm not even on the third line of the case yet. Okay? So we have here a situation, right? Where in the very outset of the case, before you even go anywhere, you know a lot of the information about the case. You know where it is, right? You know what the year, 1805. You know who won in the lower court and who lost in the lower court. Okay? This is stuff you'll internalize. You'll just look at the caption of a case. This is, by the way, everything above here is called the caption, right? You look at the caption of the case, say, oh yeah, boom. I know exactly what's going on. Pearson appealed. Yes, sir.
So, firstly, it was trial, which would have been post versus Pearson. And then there's an appeal.
Which is Pearson v. Post.
There would be another layer between the trial and Supreme Court.
Here there wasn't. So it wasn't so clearly cut in New York at the time. So I'll get there right now. Okay, so it'll be my one question pass. So, what's your name? Pablo. Okay. What's this Tompkins J business? What is that? Good. What does the J stand for? So you're smarter than me. So again, in my ignorance, my first week of law school, for the first about 3 weeks of law school, I was like, wow, all these judges have J as a first initial. I swear. Like, wow, all these, I mean, I'm Josh, this is great, right? But, you know, it didn't occur to me until maybe 2 weeks, like, oh, that means judge. So probably you're one step ahead. What I really went crazy was JJ, which means judges, plural. Whoa, right? I thought they meant junior judge for a while, but it doesn't. Anyways, yeah, so Tompkins J, Pablo, deliver the opinion of the court. What does that mean, Pablo? What does it mean, opinion of the court?
Find I would say the reason behind the holding, the set of rationale, facts, everything.
So how many judges are on this court?
The Supreme Court, that's not much.
Neither am I. But we know that there's more than one. So what you have to remember is that an appellate court, virtually every decision you'll read this year, virtually everyone will be an appellate decision. It's usually more than one court and almost always an odd number. You never have an even number of judges because that's a recipe for ties, and we don't like ties. Okay? So we know there's more than one judge, usually 3, 5, 7, 9, whatever the number is, right? Our U.S. Supreme Court has 9. Texas Supreme Court has 9. Most courts of appeal sit in 3s, whatever. So if there are 3 judges, okay, so what's your name? Chad. If there are 3 judges on a court, just make it easy. How many judges you need to have a majority? Duh, right, 2. Easy, right? Obvious. So when it says that Tompkins delivered the opinion of the court, let's assume there were 3 judges. How many people agreed with his decision? At least 2, right? None of that's written here, right? None of that is written. But what you need to know is when you have when it says opinion of the court, that means a majority of the judges on the court agreed with Judge Tompkins. Everyone see that? Okay, so let's scroll down for a minute to page, top of page 4. Okay. And Chad, we have here Livingston J, who writes, my opinion differs from that of the court. What's this about? A dissent. What is a dissent? Okay, good. So again, when you have an appellate court with 3 or more judges, not everyone will agree. And if some of the judges, what we call the minority or the dissent, doesn't agree, they write their own separate opinion saying, no, 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 no. This is how the case comes out the other way. Okay? Ma'am, in the back, what's your name? Tasha. Tasha. Why do we publish a dissent? Why am I giving you this dissent if it wasn't what the majority thought? Why? That's a good point. Why?
It may lead to different views and different outcomes of different cases.
Good, good. We put dissents into your books you have to read because they teach different lessons. One of the most dangerous fallacies a law student makes is they assume the majority opinion is always correct. No. In fact, if we're still reading a dissent 200 years later, that means it made some good points, and the issue isn't entirely clear. Do not skip the dissent. Law students are terrible at this. Say, oh, I'm not going to read the dissent, right? Well, first of all, ma'am, what's your name? Michelle, why do you think, not you, why do you think a law student would decide not to read the dissent? What do you think that would motivate the decision?
Just because I have nothing to do with the outcome of the case.
Yes. So, Michelle, let me ask you a follow-up question. If you're a lawyer, right, and you're writing a brief to a court, can you cite a dissent?
I believe it doesn't have any authority.
Good.
Binding authority. So
What's this binding authority business?
binding authority would be like actual decisions or something like a law or the Constitution, something that has the authority to kind of I guess what you decide from.
Good.
Whereas something that's not binding authority would kind of be like opinions, dissent, or anything like that.
So, sir, okay, so what's your name, sir?
Rex.
Rex? Rex. So if you're a lawyer, which hopefully will be in a couple of years, and you're writing a brief, and you have a case involving, robbing foxes, I don't know, right? Crazy case, right? And you want to cite Pearson v. Post, right? And let's just say you're in New York to make it easier. Why can you cite this decision? What about this decision means that you can cite it? Why is it something relevant that a judge should listen to? Let's pretend you're in New York.
The majority opinion?
Yeah.
Because it sets down a precedent.
Ah, what's this word precedent? What does that mean?
It means that it becomes established as common law.
Good. What's this common law business? You keep saying good things, but you ask me more questions.
I should be answering.
No. And see, this is what law school the rub. Socratic method means the more right things you say, you keep talking. This is like perverse, right? Like I remember once I was in law school, I'm gonna give a wrong answer. I want to sit down already, right? But the more correct answers you give means you're on call. So what's this common law business?
It's established law that's rulings that have been set down in the past by previous courts.
Okay. And why do we follow that stuff?
Because it helps us keep a good understanding of what law is and how we should make our decisions.
Okay, good. So basically everything that you do in law school is based on what we call precedent. Some judge in some relevant court made some decision in the past. You have to try to prove to a court this is persuasive or this is binding. Court in the future, you need to follow what the judges did 200 years ago with the Fox case. Why? Well, these cases are similar. The majority opinion, right, when it says the opinion of the court, that means the weight of the New York Supreme Court is behind this decision. You're not just saying this is what Josh thinks, right? This is the actual decision of the court. Now, ma'am, what's your name? Heidi. Now, let's say you're a good law student. You read the entire decision and the dissent, right? And, your client, right, is the one who did the hunt. Your client was the one who did the hunt. He did his elaborate hunt, and then some jerk stole his fox. Which one do you prefer, the majority or the dissent? Your client was the jerk. I mean, your client was the hunter. He had this elaborate hunt with all the foxes and the hounds and all this other stuff, and then some jerk came and stole his fox. Which opinion do you like better? Let's take one step back. What did the court hold, Heidi?
Supreme Court or the
No, the Supreme Court. The court we're talking about here. What did Judge Tompkins hold? This is the question we'll get on Monday, right? Ms. Heidi, what was the holding of the case? What was the holding of Judge Tompkins? You can look at your notes.
The jerk.
Good. Yeah, come the jerk. That's fine.
The jerk was the one who got to keep the fox.
What? Okay. Good.
The other guy,
The hunter.
the hunter. Sorry, I'm horrible with names. The hunter did not have the animal in a trap or some way. Show that
Good.
it's his.
Right. That's right. So the majority said the jerk gets it, and the dissent said the hunter should get it. Okay. I use hunter and jerk because it's easier because they both P and they confuse me every time. Okay, that's fine. And so what's your name?
Reagan.
So Reagan. So I'll ask you the same question as Heidi. If your client was the hunter, right? Which decision do you want to cite? In this, when I say decision from this document, you want to cite the dissent, right? You think, oh wow, the dissent's all right. Can you cite the dissent in a court opinion in New York? I mean, in a legal brief in New York. Well, so here's the rub, right? You could cite it, but it's not persuasive. In other words, the Supreme Court will say, why are you giving us a dissent, right? Give us what the court held. And the court held that the jerk who actually captured the fox gets it. Right? So then again, the question I asked a minute ago, why are we teaching you the dissent? Well, because the dissent here had some interesting things to say. It looked at the question very differently. It said, well, you know, if you give it to the jerk, then who's going to want to hunt anymore, right? Who's going to have any incentive to go hunting? Anyone a hunter in this room? So I'll just pose this out right here. Yeah, what's your name? Adrian. So let's say that, what do you hunt usually?
Whitetail, deer.
So let's say you're hunting a whitetail and you're tracking it and like you got it cornered just in the right place you want to get it. And then some jerk swoops in and shoots the deer and then runs away with the carcass. What are you going to do?
Well, this law in place, you can't take it in your own hands, right? But
No stand your ground for deer, no.
yeah. You know, what I would argue is on the dissent part is that with the whole concept of the pursuit and me being invested already in it.
Mm-hmm. How long does it take you to track down a deer? The process?
Well, I mean, you know, it's during a time of day. I've never gone to pursue when I've stayed in a hunting blind.
Oh, I see.
But I mean,
This guy's laughing.
assuming that I would pursue it, I mean, I put it in a situation where, you know, maybe I could have put it in a spot where if that guy wasn't there. I mean, I led the deer to that.
Yeah. Anyone else?
Specific location.
Anyone else who does hunting want to chime in? I think you raised your hand.
I did, yeah. I have turkey. It's kind of the same concept, right? You sit, you wait, you call it, you shoot it, and then maybe it'll run off. And if you do, then you go try to find it. But yeah, I mean, I would look at more of the dissenting opinion as well, because you can spend hours, you know, calling, setting up, doing whatever, you know, and you invest all this time into hunting the animal. You shoot it. It's your bullet that you bought, paid for, that you shot an animal with. It ran off. As often happens. And then this guy comes in and takes it. And
so, yeah.
I guess my only question would be, if I buy the bullet, shoot the animal, but I don't track it in a reasonable time, and then let's say it crosses a fence on a private property.
Ooh. Okay. Well, now you're complicating the issue, right? Which is something law students love to do. But the reason why this case is so perfect is where was the hunt held? On a public beach that no one owned, right? The wasteland, right? This gets complicated if it's on someone's private property, right? So it's my hand somewhere over there.
Yeah, I was just gonna pretty much say that. I mean, I think in today's times, for the most part, I think a major factor that's gonna play into it is, you know, who owns the land? Is this hunter, like, does he have a lease on the land? And, you know, per the lease language, does that supersede, you know, I'm the ranch owner and I'm on my ranch, but I lease this out to hunters. I mean, there's a lot of different factors that play into it. But
Well, that's a good question. So, did anyone notice? Where is it? Where is it? I always told it's wrong. Did anyone notice this word? So, did anyone look it up? All right. Who is next? Sir, did you? What's your name? Lauren. Did you see this word "ratione soli"?
Yes.
Did you look it up?
Yes.
Okay. What does this word mean?
It talks about the ownership of the land.
Yeah.
Who owns the-
Yeah, and it basically means like soil, land. Okay. If you don't know a word, and I promise you this will happen your first week of class, look it up. You all know what Black's Law Dictionary is? Okay, you don't need to buy a copy. There's a copy in the library, or they sell like a little handheld one, which don't even buy that either. Because do you have your Westlaw subscriptions yet? You know how to use it? Okay, so if you go to Westlaw, it's something called Black's Dictionary. You can search for it. Or if you're not sure, just go to the library, ask the librarian, they'll show you the book is. I promise you, if there's a word in Latin, and if it's italicized, it's a hint it's in Latin, you need to look it up. Because if you don't, press will say, Mr. So-and-so, what does rationally solely mean? You're like, I don't know. You'll say, why didn't you look it up? I don't know. Okay, you need to look that up. So the word rationally solely refers to the soil or the land you own. Okay, so it says here, and let's try and actually read. One of the things I like to do is read sentences for you, because these things don't make sense when you read it the first time. Whenever I teach a case, I go back and reread the case as if I'd never read it before. I've probably read this case 100 times, but I try and say, okay, when I was a 1-0, what the heck did this mean to me? So it says, most of the cases involving hunting have occurred in England relating to the property of wild animals, have either been discussed and decided on the principles of their positive statutes. What's your name, sir?
Kevin.
Kevin, what does this mean, positive statute regulation? What is this?
Oh, since this court was, this case was 1805, the United States hadn't really done around very long. So what this judge is doing is looking at historical precedents that you can find in where there are precedents to be found, which would be England, for our common law. So
what are these positive statutes and regulations?
So what he's saying is that they're looking at cases where there were decisions to.
What is a statute?
A statute is a law that's enacted by Congress. Or
Is that something created by courts?
no,
What do courts create? Someone said a minute ago.
common law.
Good. So there's two concepts you have here, right? You have common law, which are cases by courts, and you have statutes, what are called positive law. Statutes are by legislatures, Congress or Parliament or whatever. Right? What's the difference? Ma'am, what's your name?
Sarah.
Sarah, what's the difference between a statute and common law? What's the difference?
A statute, well, I guess it's kind of going off of what he was already saying. A statute is something that the legislature creates.
Good.
And common law is something that comes out of cases.
Okay, so what, but those are the differences, but how do legislatures approach problems and how do courts approach problems? What would the, if you were a member of Congress, by the way, law students hate Congress, all they like is decisions, right? Trust me, you'll fall into this. If you were a member of Congress, right, how would you resolve this issue? In this case, with the hunting foxes, what would you say?
I guess yesterday we kind of touched on this on lots of different subjects, but there was the case of the rights of privacy and photography. And so that could be an example of the common law. And then out of that, the legislature created a positive statute regulation.
Good.
I guess you would call it.
Yeah.
And created a statute.
Good. Good. Very good. So, ma'am, what's your name? Carissa, let me ask you this. When a statute creates, when a legislature creates a statute, do they write a long, winding 6-page opinion about Pufendorf and Barbarack? What does the legislature do? And what does that law usually look like?
I would assume it's usually pages and pages, but
For something like this, how long would the statute have to be? What's the rule of this case again?
the rule of this case has to do with acquiring wild animals.
And who gets it?
And who gets it.
Okay. If you were a member of Congress, not a law student, how many sentences would it take you to explain that rule?
Probably just a couple.
1 or 2, right? Legislatures write very short sentences. Ready? Follow this. Ready? Whoever catches a wild animal first gets it. That's it. Right? Was that so hard? So if I was a member of Congress or legislature, the town council, whatever, right? And I have this problem with all these jerks in the beach stealing foxes. Hey, you know what? Whoever catches a wild animal first owns it. No 6 pages, no talking about England and Barbarac and Pufendorf and Harry Potter, right? None of this stuff. But courts do things differently. Courts can't just come out and say, whoever gets the fox keeps it. They have to explain it. They have to provide reasoning. They have to build on precedent. They have to say, here's how this philosopher looked at it, and here's how this philosopher looked at it, and here's how this court resolves it, and here's this, and here's that. Legislatures say, screw it. Whoever gets the fox keeps it. Done. So there's a very big difference between what's called positive statutes, which you won't read much of until maybe your second year of law school. All you're going to read are cases, and this is why law students are bred to think any problem in the world must be resolved by courts, right? If there's a problem, the only way to do it is to file a lawsuit. That's the only way to fix any problem. Can Congress change the law? We don't talk about that in law school. Well, the democratic process is important, my friends, and courts aren't the answer to everything. And very often, if the legislature doesn't like how the court resolved this, they can pass a statute saying, whoever is engaged in an elaborate hunt in pursuit of an animal will keep it. You can pass a statute the other way. You don't have to go just one way. Legislatures can disagree with courts. Imagine that. Anyway, so what they're saying here is all of the cases from England have been decided on statutes. And do the English statutes apply in the New World? No. It's an interesting historical point. The American colonies basically cast off all the English law. We just sent it back across the sea, dumped some tea in the bay, and moved on with our lives. So there were no English statutes that bound the state of New York. Okay. What's this word? What's your name?
Kevin.
Kevin, what's this word? Fere naturae. What is this word?
Privilege of hunting and killing something.
Are you guessing?
No. I wrote it down.
Where'd you get that from?
I got it off the internet.
Where on internet did you look?
I Googled it and went to a website. It was translations.
Use Black's Law Dictionary, okay? Don't say internet. I once had a girl actually cite Wikipedia in class, and it was really embarrassing for her. Don't do that. You'll find case summaries on Wikipedia. Don't read those. They're not very good. There are some better ones, but use a legal dictionary. That's what you're being paid to do. So what's your name again?
Adrian?
Adrian, did you look up fere naturae?
Yes.
Okay, what does it mean?
It means a wild animal.
A wild animal, right? You were in the ballpark, but the word means wild animal. Yeah, this is actually as opposed to domesticated animals. Believe it or not, there's an entire law for wild animals versus domestic animals, right? So the fox is a wild animal. Okay? So what basically this paragraph is saying is we need to base our decision on something, right? But all the cases we have are from England. We have these English statutes. They don't bind us. We have these English cases. Those really don't bind us either, right? There was actually a very big anti-English sentiment in 1805 in New York, as you could imagine. The entire war was a touchy subject for a number of years, okay? So in the absence of any sort of statutes, relevant cases, how is a judge to resolve the case? Tara, how does the judge resolve the case?
Looking at prior decisions or writings in the law.
Good, right? Judges have to get their answer from somewhere. And in this case, who do they look to? Who are these sources of the law they look to, these writers?
Barbarac and Pufendorf.
Who the heck are Barbarac, Pufendorf, Hufflepuff? I mean, Grotius? Who in the world are these people? Here, there's a good list of them. Justinian, Fleda, Bracton, Pufendorf, Locke, Barbarac, Blackstone. Who has ever heard of any of these people? Excluding Locke. Who is any of these people? Excluding Locke and Justinian, who's heard of any of these people? That's what I thought. Okay, right. Most people know about John Locke, the social contract, whatever, state of nature. And some people may say Justinian, right? The emperor, right? But Fleda, Bracton, Pufendorf, and Barbara. Interestingly, Blackstone's not cited. William Blackstone was one of the greatest English jurists. He published what are called the Commentaries on the Common Law, which are published in the 1770s. You will read these many times over. They're a great read, or at least you should read them. I did. So, who are these people? Well, these are philosophers, right? These are people who wrote these very big, thick books about the law. And they try to understand different foundational issues. And one of the issues that they discuss, right, involves hunting, right? Believe it or not, back in the time of no internet, hunting was a pretty big deal. Hunting was a big deal. Who got a fox and who didn't get the fox could mean someone starves to death or someone doesn't starve to death. People weren't just hunting for sport, right? This was how they sustained themselves. So it's not surprising that lots of these ancient writers address this important topic of hunting. Okay, so what the court basically says here is, let's look at what these ancient writers said on general principles of law. Let's go back up here. I can't remember. So what's the name again? James, what does this mean, ancient principles? I'm sorry, the ancient writers on general principles of law. What are they saying here?
It kind of seems like they're talking about situations in which they've written about, and it's almost a natural law.
Ooh, see, we say a good answer. I ask you follow-up. What's this natural law business?
It's something that everybody's kind of agreed upon. It's the society, I guess, that's agreed
Does
upon.
everyone agree on this one? Even in this opinion?
Not in this situation.
So this idea of natural law, which you may have studied if you study religion or theology, are certain principles which hold true among all societies that everyone can agree on. It's a matter of, first principle. Probably not everyone agrees, right? But what they're basically saying is, listen, we're judges, right? We can't just make stuff up. We have to look at what someone in the past wrote and use that to guide us, right? So there are two schools of thought in these cases, right, that these philosophers kind of agree on. And so what's your name again? David, what's one of these schools of thought? This is lower than what last year. What's one of these schools of thought of how we should handle a situation where you have a guy hunting and you have the jerk who swoops in? What's one school of the philosopher's thoughts?
One school of thought is that if you have a wild animal, you don't are entitled to that until upon you killing it.
Is it just killing it? One at a time. Remember this one. The one at a time is a big one. Don't claw it when you're not in turn. Professors don't like that.
On
touching, right? It's not just capturing. It's not just killing. It's making some sort of contact with the animal. And you have to do it with your own hands, or you throw it at an animal sometimes. Yeah, right. Is this Texas? But no. What do you? What? Now what's your name? What's a way that you can touch an animal? Using your hand. A net, right? A net. So Haley, if you could summarize, what do you think give me one sentence. This is hard, right? But give me one sentence. How would you characterize the school of philosophers who took this position? How could you capture an animal? Okay, that's pretty good, right? It's not necessary to actually kill the animal. It's not necessary to actually even capture the animal. What you have to do is use something to actually make physical contact with it in a way that indicating your ownership. I'll give another side. How would you summarize in one sentence, right? By the way, this is what law professors want you to do. They say, what's the rule of the case, right? What's the holding of the case? They want you to give 1 or 2 sentences. Don't go on for like 30 seconds. Concise, right? Concise. What's your name? Adam. Give me one sentence describing how this view of philosophers works with respect to a hunter.
Like their relationship?
Give me one sentence, like Caleb did just a second ago, of how we describe the view that the hunter can get the animal without actually having to capture it.
If a person has a vested interest in,
What's his vested interest? What does that mean?
like they've put in resources or there's an intention to acquire the thing.
Ooh, an intent to acquire. Okay, so let's say I give you this is all a person do. They'll ask you a question, they'll change the hypothetical, right? Let's say like this, right? I'm hunting a fox, right? And it's like I see it at the corner of my eye, it's like I'm half a mile away, and I'm running as fast as I can, but I'm nowhere near it. And then someone swoops in and gets it. I mean, I declared my intent to catch it. I saw it. I fired some bullets at it, but my aim, was nowhere near that. I can't off my half a mile away. Does the hunter get it there? Under your rule?
No.
Why not?
Because in the case it says that just spotting the animal is insufficient.
Just spotting is not. What do you have to have? Yeah.
You have to take control and domain of the animal.
No. But that's what this is not saying.
Oh, I thought you said.
No, this is saying that it's not necessary to actually capture it. They can use like a net or throw something at it, right? So this is from the dissent, right? This paragraph. This paragraph, right? It's on the last page, page 6. Okay. If you're looking to try and find the holding of the case, as you're reading it, pay very close attention to something that looks like a holding, right? This paragraph is where the dissent explains why it's not necessary to actually capture the animal to get it. It says, and I'll just read it, that property in animals fere naturae, this means in wild animals, may be acquired without bodily touch. By the way, mancupation. What's your name, man? Laurel, did you look up what mancupation meant? Did anyone look up mancupation? You have to look up the English words too, not just the Latin ones. Anyone know mancupation? Got it?
By the root, it sounds like how to get in the hand.
Yeah. Basically bodily touching, right? Capturing with your hands, like mano, right? Mano. Capturing with hands. Okay? So it says, property in wild animals can be captured without bodily touch or hand contact, provided that the pursuer be within reach, or have a reasonable prospect of taking what he has discovered and intention converting it to his own use. So Laura, go back to this for a second, right? What are the different elements of the dissent's test? What are the different factors that you have to satisfy, capture something without actually physically touching it? There's a couple things there.
Well, in general, I think overall would be like first person, so it would be like you have to have the intention and the preparedness for the.
Well, it's right up there.
Well, but it's in like crazy language. So.
Crazy language. Well, this is what
I'm
you.
trying to put in my words.
Well, read it clause by clause. Please. Can you see it? Or it's on your paper too.
That property in animals may be acquired without bodily touch or manipulation, provided the pursuer be within.
Stop. I'll continue a second. What does that mean? Provided that the pursuer be within reach. What does that mean?
Well, this is a little like iffy for me because I'm not sure if they actually mean like within reach, like if it's called within my reach, or do they mean like within reach of whatever tools you have to go out on the hunt.
So what's the answer?
Well, I assume it was tools to go out.
Does that mean like if my arm is this long So the fox has to be
I
like
don't
here,
think so, that would be
right? Because if you're that close, you're probably going to catch a fox. What's your name again? Isaac, what do you think that means pursue provided within reach?
It can mean either within physical reach or having a reasonable prospect of achieving.
Well, that's the next one. Let's just say within reach for a moment.
Within that, it's within mere moments of capture.
Ah. So you see, unlike legislatures who can say, if you're within 25 feet of the animal, it's yours. Courts don't write like that. They make what are called standard, not rules, but general standards, right? So what's your name?
Chase.
Chase, let me ask you this question. What if, a case comes by, let's just pretend for a moment the majority was wrong. Let's pretend the dissent was correct, right? Let's pretend the dissent was the full opinion of the court. And let's say you're hunting a fox and you're, like I said, half a mile away. And say you're a sharpshooter. You can shoot a fox at half a mile, no problem. And then, as you're about to, pull the trigger, some jerk swoops in with his orange vest. Damn, I can't shoot, right? And then he swoops away at the fox. Were you within reach of the fox? Okay. Now you're the lawyer for the other guy.
Okay.
You're the lawyer for the jerk.
Okay.
And I ask you, was the hunter within reach? What do you say?
I said, no, he wasn't. He wasn't close enough to make a capture.
Right. So you see that this language opens up to a couple different meanings, right? If you're the lawyer for the hunter, it's like, oh my God, my client was a sharpshooter. He can shoot a nickel at 100 yards, right? Or this guy's saying, he could have hit the broadside of a barn, right? So you see that even the dissent leaves us up open to a different, this is what lawyers do, right? They say which is more persuasive. Okay, so now, what's your name again? Jose. So read the next clause, or have a, starting there. Of, so what does this word mean, a reasonable prospect? What's that phrase mean?
Perhaps that it was reasonable that he was given chase.
A reasonable prospect of what? Blank. A reasonable prospect of, what does that mean, taking? Taking what? Good. So, Jose, let me ask you this question. What does reasonable mean? Lawyers love this question. What's reasonable? Oh, reasonable person. What's this? Someone did their reading, right? What's reasonable person?
You have to stick with potential certainty that something is done.
Now, what if I say that it was perfectly reasonable for a person half a mile away to be within reach? Perfectly reasonable. Am I right?
Sharpshooter, yeah.
Well, what does it mean for reasonableness? Who are we looking at? Is it my own personal opinion? Is it the lawyer's opinion? Is it the judge's opinion? Whose reasonableness are we checking? Ah, the reasonable person. You said it already, right? The reason we have the reasonable person standard, which apparently you've read about, which is good, is that reasonableness is often subjective, right? If I'm a good hunter, I would say, of course that person can hit that shot. If I don't know anything about hunting, I'm like, there's no way he could have hit that shot, right? What the reasonableness standard tries to do is what's, the average person in society, someone who comes to this picture with, not an expertise, not a specialization. So that's why lawyers often put this word reasonableness. So if it's a jury trial, you say, well, the jury can determine what a reasonable distance is. How far away can you be reasonable? Maybe you bring in experts testify about, shooting capacity. The guy has, medals in target shooting from 500 yards, right? You can figure that stuff out. Yes, ma'am.
What about the CSI?
Oh, tell us what the CSI effect is.
CSI effect is the fact that TV and media has skewed a person's view of what forensic science can actually do.
Yeah, this is actually very dangerous. So everyone knows CSI is the show. It's called Crime Scene Investigation. I've never actually watched it, but they always have these like a miraculous forensic experts who come in and say, there was like a shrapnel of grass on his foot, which was from a specific part of the country where he must have got. I mean, it's crazy stuff, right? And they often create very high expectations that forensic scientists can come in and prove the entire case, and frankly, they can't. So let me explain something to you. Forensic evidence is not very accurate, okay? It isn't. DNA evidence doesn't actually match someone. All it says is there's a substantial chance that they are the person. So everyone's seen Maury Povich, right? It says, you are the father, right? Not exactly. It says there's a 99% chance that you're the father. It's not exactly, we can't prove someone's DNA precisely. So when you have someone's life on the line and you have, say, a 97% match, is that good enough evidence to convict someone? Right? So it happens. So the CSI effect is certainly there. But this case was long before CSI and long before anything, right? Which is why we give you these old cases. They're so simple. It's two guys fighting over a fox, right? Okay. So anyway, we have here then this test. We say, okay, how far is this reach? What is his reasonable prospect, right? And this last part, what's his name? Pablo. What's this? He has, read this one. He has thus, this part. Yeah. Okay, so what does this mean?
If he were to, assuming fall within the aforementioned, without bodily touch, without within the region, hits all the different markers that define
Okay. How do you what's his name again? Chad. How would you read this last provision? What's this word intention mean? Okay, so let's say like this, right? I'm walking around the forest. I see a fox half a mile away. I'm like, maybe I'll get it, maybe I won't. I don't really know. And then I see this jerk swoop in and take. It's like, oh, that was totally my fox. Was it within your reach? Yeah. Did you have a reasonable prospect of taking it from that distance? If you're a good shooter. Yeah. Did you have an intent to take it? Well, nothing about effort, but did you have an intent to take it? Should we reward someone who didn't even intend to take the fox? So you see why this last one's important, right? It's not just that you're in the area and you're close enough and you could take it. You have to actually intend to take it, right? We want to actually only give it to someone who expressed an intent. So, and what's your name again? Tasha. So this sentence, which we spent about 10 minutes on, right? How many different elements are there that have to be satisfied? What are they?
The intent.
Good. Well, put them in the order in which they appear in the sentence.
Bodily touch.
Well, no. Does there have to be bodily touch?
Or like you could have it at something.
No. But this is actually. I'm glad you said that. I thought that's what you were going to go for. This is not an element. If there's no bodily touch, then here are the rules, right? If there's bodily touch, is there any dispute over who gets it? No. If I actually go there and I get the fox and I'm holding it, right? It's going to be mine. But the question here is whether you can acquire something before you touch it, right? Whether you can acquire something before you touch it. So Tasha, try it again. What are the rules if you what are the elements you have to satisfy to acquire something without touching it? One, right? Two. Three. This one's easy because they're listed in order with commas separating them, right? It won't always be this easy. But the test from this paragraph is how do we acquire an animal in the absence of bodily touch? And the dissent says, well, tense majority, there are three things that have to happen. You have to be within reach. You have to have a reasonable prospect of taking it. and you must have actually intended to take it. This is what we call a test, a three-factor test that can be applied in a different situation. So to use the example I asked a Chad about a minute ago, what if you were close to a fox and you were within prospect of taking it, but you never intended to take it? Well, too bad. These are 3 requirements that all have to be met. And what you'd have to do in a future case is argue along these 3 requirements. Any questions about that?
I have.
Yes, sir.
So for instance, say this is an exam question and there's 3 elements that are there.
Mm-hmm.
So I've read different books, of course, I don't have experience in this, but it's like the first element, I would argue one side for the plaintiff of how he met it or didn't, and then argue the defendant, and then get the next element and go back and forth like that, or how would you approach this on an exam? I'm trying to like.
Oh man,
see
you
if I'm
are
satisfying all the elements.
you are way ahead of asking about exams. Law students, know what the quickest way of making a law student tune out is? Say this is not an exam. As soon as I say that, it's like, right. So
Yeah, you got me a little shaky.
the shorter answer is that every professor has a different exam style, which will drive you nuts. Every professor you have will want something different in an exam. So rather than asking me, you should ask your own professor, and preferably do it in office hours. Like this is, I said this before, go to their office hours. They're posted for a reason. Go take an hour, right? And go talk to them. They will appreciate it. Even if you ask really incoherent questions and they say, go research it yourself, at least it'll show you're inquisitive and you're trying to learn. So my first answer to you is go talk to your professor, okay? My second answer to you is what law professors are looking for is your analysis. It's perfect if you can state the rule, saying, okay, here are the 3 elements necessary to catch a fox. Therefore, my client wins. No. You have to say, okay, so here are the facts. My client was 25 feet away from the fox. Therefore, he was within reach. My prospect was an expert sharpshooter. He could have definitely had a reasonable prospect of taking it. And my client said, I'm getting that fox. He expressed his clear intent to take it. Therefore, under this rule, even though he didn't physically capture it, possession goes to the hunter, to the jerk, whoever it is. You don't call your client a jerk. Right? Yes, sir.
About the 3 elements. Now, I know it's not listed here, but kind of as we're reading it, what about, what I'm getting at is, would being on public land have to be an element too?
Oh, I'm so glad you asked that. So one of the reasons why these opinions are 6 pages long and not 2 sentences, right? Wouldn't it have been awesome, right, if the entire case was just this 1 sentence, right? Wouldn't that be awesome? But it's not that simple. So was it Chaz?
Chase.
Chase asked, what about the stuff about being on private land, right? What if I have a reasonable prospect of capturing an animal and I intend to do it on private land? Is it mine?
I guess not, because they're bringing up this whole rationing solely.
Yes, but is there anything about rationing solely in this paragraph? Oh. Is there anything in this paragraph that we've been studying for 20 minutes about private land, rationing solely? Where'd that come in? Somewhere else. This is what drives law students nuts. You cannot reduce a case to a single sentence because you're omitting all the other stuff from the first half, right? Remember where they said like 8 paragraphs earlier, if it's on private land, it's a different story? So you'd actually have to effectively modify this saying is on, public land, if it's reasonable prospect, all this other stuff, right? So it's not so simple to actually just, read the holding of the case. This is why, for those of you who have checked black letter outlines, his commercial outlines, what he just said won't be in there, right? When you try and reduce a case to a paragraph, they're going to miss really important stuff. They'll just omit it because they don't have time to capture it. This way you have to read the entire opinion. Because say like you read the black letter outline, you could say, oh yeah, here are the 3 factors. Okay, great. And the professor says, but what happens if it's on private land? You're like, huh? That wasn't in the holding. And then you look like a fool. Trust me, you'll see this your first month of class. Someone who has by the way, do not bring those outlines to class. You know, like the Blacklear outlines, Gilbert's, right? Don't bring those to class because we can see. We're looking down. We see what's on your table. We see what's underneath your desk. It's not hard to hide. We can see your phones also, right? We know, so don't bring those to class. If you want to read them, fine, but do it in addition to the opinion, not instead of. Okay. All right, we have about 5 minutes left. That clock is someone made it way too early. I don't know why. We have about 5 minutes left to get to your next exercise. I want to save this for questions. And again, I don't know any of you. I won't have any of this semester. I'll probably forget a lot of your names, which is part of your benefit. So if you have any questions, you can ask me now or come up or whatever you want to do. Questions? Anything about the orientation so far that's confused you or you didn't understand? Anything about classes or anything about the law school? Yes, ma'am.
Just kind of a general thing. How would you use like those PMEs and like supplemental material towards kind of studying?
You need to ask your professor because some professors like them, some don't. I like them. They're good as a supplement, but always do the readings the professor tells you. Yeah, you'll have what 4 or 5 professors this term. They'll all do everything totally differently. Every 90 minutes, you have to change everything. How you want to recite cases, how you're going to take notes. I mean, it's going to be a different world of experience. It's actually very surreal how inconsistent we are among ourselves. We'll get you there. Yes, sir.
I have a follow-up question I asked about earlier. I want to clarify it a little more. So, like, let's say you're at the trial court, the lowest court, and that court makes a decision, the other side appeals. You flip the names on top. Then you petition, and it goes the other way. So then they petition to go to the Supreme Court. They say, yes, you can. Does it then flip again?
Absolutely.
Okay.
Keeps flipping. Any other questions? Good luck. Hope all of you do well. Work hard and take care of yourselves. Thank you. Thank you so much. Thank you.